So, distinguished guests and friends, it's a pleasure to welcome you to tonight's edition of the ICTY Legacy Dialogues Series, this time on the role of the prosecution. And I think I'm happy to see that each time we organize such an event, we seem to be growing. So that is, I think, very good news. It's, of course, very timely to reflect on 20 years of ICTY investigations and prosecutions. The Tribunal went a long way. At the beginning, there was skepticism whether the Tribunal would actually indeed get any cases in the first place. Richard Goldstone, the first prosecutor, admitted that, of course, Tadic was to a certain extent a choice of convenience. But then the strategy went gradually up from certain low-profile to mid-level perpetrators to the leadership. On the way, there were, of course, successes and there were failures. But today, the ICTY is celebrated for having arrested all indicted suspects, and I think this is really a truly unique achievement. The ICTY experiences tells us many lessons, I think, about modern understandings of the prosecutorial function. International prosecutors typically enjoy a higher degree of discretion in the selection of cases and in the framing of charges than some of their domestic counterparts. But they're also crucially dependent on cooperation, and they're de facto responsible to a larger amount of constituencies. The ICTY has shaped many of the modern techniques of investigation, and this before the rise of some of the new technologies that we have available today. I think the Srebrenica investigation still stands out as an example. Forensic evidence and aerial footage managed to reconstruct how the bodies were moved to the secondary graves. The ICTY has developed new rules and practices to facilitate testimony regarding sexual and gender-based crimes and to avert traumas of secondary victimization through questioning in court. It has relied on written statements, prior transcripts, and judicial notice, for instance, in order to reduce examination and cross-examination of sexual violence victims. Victim consent is deemed to be vitiated or disallowed as a defense. Prosecutorial charges have also paved the way for many modern constructions of crimes, including genocide, rape, the destruction of cultural heritage, and there are many other examples. Another innovation is the collaboration of prosecutors with the region. Many of these lessons are collected in manuals or volumes. One example is the book edited by Serge Brammertz and Michelle Jarvis on conflict-related sexual violence, published last year. Of course, ICTY practices cannot be transposed directly to other legal frameworks, since procedures and structures differ, but they provide certainly useful guidance to avoid mistakes of the past. So we are very pleased to have here tonight with us some of the leading protagonists of the prosecution who have shaped the practice over the last decades. It's a pleasure, first of all, to give the floor to Michelle Jarvis, who will introduce the panel. Michelle, it's a pleasure to have you here.
Well, good evening, ladies and gentlemen. It's really my pleasure to formally welcome you here this evening on behalf of the Office of the Prosecutor. We, of course, have quite a big challenge ahead of us to work out how we can try and reflect back on almost 25 years of work in the Office of the Prosecutor in just the 2 hours that we have available to us. And we've chosen the theme of starting from scratch, because what we really want to do in the discussion this evening is to capture a little bit of the inside story inside our office over the years, looking at what it was like to actually build from the ground up the first modern-day international war crimes prosecution office. I think about my own experience coming to the ICTY for the very first time, which was back in 1997 as an intern. And in those days, it still did feel a little bit like the Wild West in the OTP. I remember very well a comment from a staff member who was there at that stage, who said to me, "Everything that we do All day, every day is difficult. Nothing is ever easy. There's no precedent for anything that we do, and there's no straightforward answer. Every single issue, legal, operational or otherwise, was novel and required deep and creative thinking. My own first assignment as an intern upon arrival in the OTP was to help research the issue of whether the crime of rape could be prosecuted as an act of genocide. And this was an issue that had come up, of course, in the Rwanda Tribunal, our sister tribunal that had been newly established at that stage in the Akayesu case. So for me, as an intern, a newly minted postgrad student, interested in international humanitarian law, interested in gender issues, I couldn't have imagined a more interesting and worthwhile assignment. And certainly for me, it whet my appetite for the practice of international criminal law. For some staff members, of course, these sorts of intractable challenges were something to be experienced for a brief period of time before perhaps returning back to the more predictable environment of national practice. But for many staff members in our office, I think that the sheer challenge and novelty of the work really became infectious. So I think what really helped with this, of course, was, as our work proceeded, seeing that there were avenues for having an impact, and there really was a prospect of bringing about some sort of measure of meaningful justice for the victims. I think the panel that we have composed tonight is a really good example of what I'm talking about. People who really have spent large parts of their career dedicated to the practice of international criminal law, who've worked inside the Office of the Prosecutor for many, many years, and who've really been at the coalface of developing a lot of the innovative approaches that I'm talking about. We have, of course, Bob Reid, who's our Chief of Operations, Laurel Baig, a Senior Appeals Counsel, Doug Stringer, a Senior Trial Attorney who has overseen many of our most important cases, Dorothea Hanson, who's an analyst and has been working for many years in the analytical work that we do, and of course Peter McCloskey, who is our leading trial attorney, senior trial attorney in the Srebrenica cases that we've prosecuted over many years. So looking back over all of this experience, what have we learned about the ideal characteristics of an international war crimes prosecution office? Well, definitely safe to say we've learnt more than we'll be able to go through this evening, but certainly I think we have learned that to move forward with this sort of work, we need bold moves, we need sheer persistence, and we need adaptability inside an international war crimes prosecution office. And I think overall what we need is an unshakable sense of optimism that the impossible might just become possible. Bold moves. Well, we've seen that over and over again in many areas of our work, and I'm sure the panellists will give plenty of examples of that tonight. A real willingness to step outside of our comfort zone and just have a go at novel strategies. One example that comes to mind for me is in the area of conflict-related sexual violence. Many of you will know the prosecutions that we brought over the years in relation to Focha municipality. We investigated the mass rapes occurring in Focha, and of course under the ICTY statute we could prosecute rape as a crime against humanity. It was expressly referenced as such. But when we collected the evidence in the Focha cases, we realised that the crime of rape wasn't going to fully capture the damage and the harm caused to the victims. The women and girls, of course, had been raped multiple times, but they'd also been imprisoned and forced to perform domestic work and bought and sold among the soldiers. So we came up with the idea of possibly putting this evidentiary package together and charging it as enslavement, as a crime against humanity. Sounds obvious to us today, but back then this was a really novel idea. And within our office, there was significant discussion about whether this was a good idea. Were we pushing the boundaries too far? Would we risk getting an acquittal if we put forward a novel legal theory that the court would not accept? Today, of course, the Kunerarts case, the Focher case, where we first prosecuted enslavement based on sexual violence, is a well-known and groundbreaking precedent that is being used all around the world for similar cases. So it's worth pushing the boundaries, but it does require a degree of bravery and risk in an appropriate way. I mentioned also sheer persistence. I think the very best example of this is, of course, the work we've done over many years to arrest the fugitives indicted by ICTY, and Bob will talk a little bit more about this. We used so many different strategies over the years to lead to the arrest of the final fugitive, Goran Hadžić, in 2011. We used a combination of sealed and unsealed indictments at different points in time, depending on the political climate. We, of course, had to engage heavily with the international community to convince them to carry out the arrest that we needed. We also, of course, had to use very creatively strategies like conditionality through the European Union, the idea that progress of the countries of the former Yugoslavia towards EU membership would be made conditional upon full cooperation with the ICTY. I also mentioned the quality of adaptability. Of course, when the ICTY started out, nobody was really thinking about prosecutions at the national level in the former Yugoslavia. Our framework was very heavily centred on the international level, and ICTY, of course, has primacy of jurisdiction in the statute. But as the ICTY completion strategy came into being, we realised more and more that our focus had to shift into supporting more and more our peers, our colleagues, our prosecution colleagues in the national jurisdiction so that they could continue the many hundreds, even thousands of cases we would never be able to prosecute. So again, this required a lot of creative strategies on the part of our office, and it has, I think, become one of the most compelling parts of our legacy at the end of the day, the model whereby an international court or tribunal can be used as a springboard for building national capacity and seeing the national and international working in tandem. We've had programs supported by the EU, like the liaison prosecutors who've come from Serbia, Bosnia, Croatia, and worked within our office here in The Hague. And we're also working with partners like the International Association of Prosecutors to set up networks where we can really facilitate these peer-to-peer discussions. So to conclude, I just want to say a brief word about the idea of impossible mandates in the field of international criminal law. I think so many of the international justice mechanisms that exist today face what do appear to be insurmountable hurdles. If we think about our colleagues working in the Special Tribunal for Lebanon, previously the Special Court for Sierra Leone, the ECCC, the new IIIM, the Syria mechanism, they all face their own distinctive and formidable challenges to meeting their mandate. But perhaps the final story of the OTP is a lesson that sometimes the seemingly impossible can indeed become possible. And that, of course, all depends on the people inside these institutions. In the OTP over the years, we've certainly had staff members demonstrating remarkable ingenuity, formidable skills, and unshakable commitment. And I think our panel tonight is composed of some of the very best examples of that, and it's my pleasure to now hand over the floor so that you can hear more from them. Thank you.
Good evening, everyone. Welcome, and thank you very much for taking the time to come and listen to our stories, which is what this is mostly going to be about. My name is Doug Stringer. I arrived at the OTP for the first time back in April of 1997. I had been a prosecutor, a federal prosecutor, back where I come from in the United States. I was with the tribunal for about 5 years during that period, and I was involved in 2 trials before returning back home for what I thought would be the continuation of a domestic career. But like so many of us, I was drawn back to this work, and I returned then to the OTP in April of 2007. So that brings me to about 10 years or so, more than 10 years now since I've returned. Before going to our panelists, I'd like to share with you for a couple minutes some of my impressions of what it was like 20 years ago in April '97. When I arrived at the Office of the Prosecutor, assigned to the trial team in one of those early trials, Prosecutor versus Tihomir Blaškić. What were some of the challenges and questions confronting me and other investigators, analysts, lawyers, charged with the responsibility of investigating and prosecuting the first war crimes prosecuted in international tribunal since Nuremberg? It felt so new, so urgent, and so important. And the world was watching closely to see if this fledgling tribunal would take off and fly or crash and burn. Michelle's already referred to this, and it's very much true. It was never clear whether this was going to succeed at all. It was an experiment. And there were times in those early days when we really didn't know how things would turn out. In fact, there was a great deal that we did not know. Where are the bodies? So many thousands were missing. Proving death was an issue. Local authorities had collapsed in many areas, of Bosnia in particular. There were no death certificates. In the Blaškić trial, we had the witnesses bring photos of family members killed in the village attacks that they were testifying about, and the photos were admitted into evidence. It was the best we could do. And where were the witnesses? So many thousands had themselves been displaced and ethnically cleansed. Can we count on the cooperation of the local authorities when we come to investigate? In the statute creating the ICTY, the UN Security Council provided that states must cooperate with us. But how do we compel that cooperation? Can we conduct basic law enforcement investigations in these places, searches and seizures, summoning witnesses, people of interest, to come talk to us? What's the evidence of the political and military structures on which we will rely to prove who had real power, de jure and de facto, constitutions, laws, military regulations, chains of command? Most of us didn't even speak the language, much less understand the political, military, and cultural traditions of Yugoslavia, knowledge that was vital to prosecuting the leadership cases. We had conventional and customary law to tell us what's unlawful in armed conflict. But the Geneva Conventions and the additional protocols, those aren't a criminal code. The crimes that they prescribe had never been prosecuted in an international criminal tribunal. So what are the essential elements of the crimes that I have to prove beyond a reasonable doubt in a court of law? What are the essential elements of the crime of unlawful attack directed against a civilian population in violation of the laws and customs of war? For example, proving crimes against humanity requires proof of a widespread and systematic attack directed against a civilian population. How much widespread and systematic is enough? How does one prove the existence of an international armed conflict necessary for proving grave breaches of the Geneva Conventions? These were a few of the many fundamental legal questions for which there was no clear answer, no precedent. Every one of these questions was agonized over by investigators, analysts, and lawyers in the Office of the Prosecutor in those days. And now, some 20 years later, we pretty much know the answer to these questions. And in the process of finding those answers, some 161 individuals were charged in OTP indictments with responsibility for the worst crimes known to mankind that were committed throughout Croatia, Bosnia, and Kosovo. For me, this is the legacy. This is the story of the OTP. Each of our panelists was among those investigators, analysts, and lawyers in the OTP in the early years, trying to find their way, trying to find the answers. And as Michelle so spot on said, it took bold moves, it took persistence, it took adaptation, it took creativity. It still does. But in those days, when there were so many questions, so little guidance, it was even more so. The first of our panelists who's going to speak is Bob Reid. He's probably well known to many of you. Bob arrived at the Office of the Prosecutor in June of 1994. I don't know if anyone else actually was there before him. He arrived coming from the police department in Sydney, Australia, where he had been a detective for 20 years. Bob played a key role as investigator during the investigation and the trial of the first trial at the ICTY, the prosecution of an obscure camp commander who had the unfortunate notoriety of becoming the first accused to actually go to trial at the ICTY, Duško Tadić. Bob's now the Chief of Operations, and I don't know that there's anything that happens in the Office of the Prosecutor that isn't in some way touched or shaped by what Bob does. Bob was involved in the early days of development of guidelines, policies, practices within the investigation side and more broadly throughout this fledgling Office of the Prosecutor. And it's my privilege now to introduce or turn the floor over to Bob to hear his story.
Thank you, Doug. As Doug said, on the 7th of June 1994, I arrived in The Hague in the Netherlands to take up my new position as an investigations team leader in the newly created Office of the Prosecutor of the International Criminal Tribunal for the former Yugoslavia, or more commonly referred to as the ICTY. I was one of the first investigators to arrive. There was no prosecutor. Apart from the deputy prosecutor and a small contingent of 22 seconded lawyers, investigators and diplomats, we were it. There'd already been one conflict in Slovenia, two were still raging in Croatia and Bosnia, and the international community and others were screaming that they wanted indictments, they wanted Karadzic indicted, they wanted Milosevic indicted, they wanted Tudjman indicted, and they wanted Izetbegovic indicted. So how did we go about going into this not so difficult assignment? How did we commence our investigations? What crimes did we decide to investigate and why? How did it come about that we indicted 161 persons for crimes committed in 5 conflicts in Slovenia, Croatia, Bosnia, Kosovo and Macedonia, and account in some way, shape or form for all 161. When I arrived, we had very little budget. We had no standardised guidelines or standard operating procedures to operate by. We had a very small staff who needed to go to work immediately, and limited recruitment had taken place. So we started by putting the infrastructure in place. We wrote guidelines, we wrote standard operating procedures, we wrote policies. Policies and guidelines on simple things like how to take a statement, how to work with interpreters, how to seize documents, what had to be done with those particular documents once they'd been seized. In essence, how do you preserve the evidence that you're collecting? And a multitude of other issues that rose on an almost daily basis. We also went about recruiting staff from all over the world, investigators, lawyers, political analysts, military analysts, criminal analysts, interpreters, and of course the vital support staff that worked with us during our investigations and prosecutions. We also decided that there was a need to have field offices in the region, and we set up field offices in Zagreb, in Sarajevo, in Belgrade, and subsequently we started new field offices in Pristina and Skopje as well. At the same time as doing this, we had to, it was putting the infrastructure in place, we had to look at what the evidence was. Where were we going to collect the evidence? Where were we going to get the witnesses? And there were a number of references that we could use, and one in particular, the first and foremost that we used, was the Commission of Experts that had been chaired by the late Professor Sharif Bassioni. The Commission of Experts material at that stage could not be used to confirm indictments or even be called really evidence, but it was valuable to our work in that it gave us leads. It gave us leads to witnesses. It gave us leads to crime sites, to detention facilities, to prison camps, to mass graves, etc. We reviewed that material. We also reviewed material that came from the NGO community, the human rights organisations, and individuals writing to the Office of the Prosecutor, making their individual allegations. So how did we go about choosing our investigations? Well, it was pretty simple, really. We went where the evidence took us. After examining the material at our disposal, we decided to embark initially on carrying out an investigation that was identified by the Commission of Experts in the municipality of Prijedor, which is in northwestern Bosnia. We also did an investigation in relation to Vlasenica, which we had got from a particular government report, and 2 or 3 witnesses who were living in Rotterdam in the Netherlands at that time came into our office late one night and reported that they had been victims of the crimes that had occurred in the municipality of Vlasenica. At the same time, we continued our recruitment process and were quickly able to put together teams that were able to investigate crimes that were committed by Bosniaks, crimes that were committed by Bosnian Croats, and crimes that were committed by the Serbs in the various conflicts. We also carried out an initial assessment of alleged crimes in Slovenia and put together a team that commenced investigations in relation to the crimes that the JNA had committed in and around Vukovar and Dubrovnik. Now, all these investigations that we were doing was what I call crime-based evidence, and it's essential to be able to get that crime-based evidence to work your way up the chain of command. And it's pretty much a pyramid investigation. You start at the bottom and you work your way to the top, and it comes at the peak. So the evidence that we gathered evidence from eyewitnesses, we gathered evidence from such as people who were the victims of the crimes, who witnessed the crimes. We gathered evidence from diplomats who put certain officials on notice that crimes had been committed and what the reaction to those particular allegations were. We took statements from people, if, for example, UNPROFOR officers in relation to the proportionality of an attack, and the UNPROFOR officers played a big part in the trial that Doug was talking about in Blaskic in central Bosnia. We also took statements from human rights monitors. For example, in Kosovo, Human Rights Watch had a very, very big presence, and we took statements from 2 of their human rights monitors, and they gave evidence subsequently in trials. And of course, we took evidence from what I call experts, pathologists who carried out autopsies on the victims from the siege of Sarajevo or from the atrocities that occurred in Srebrenica. We took evidence from military experts, from diplomats, etc. And without this type of evidence and the proof that the crimes occurred on the ground, there could be no indictments issued, because we could then not work our way up the chain of command. As this evidence was being gathered, the process of putting the material together to support an indictment was ongoing and taking place. For the individual perpetrators of the crimes, this was done rather quickly, and indictments were confirmed against Dragan Nikolic for crimes that occurred in the Susica camp in Vlasenica, and against the leadership of the Omarska and Keraterm detention facilities, or camps in Prijedor, together with a number of the lower level camp officials and what I called visitors to the camp of Amaska and Keraterm, and crimes that had occurred outside of the camp regime. For example, crimes that occurred in the municipality, in villages such as Hamburina and Kozarats. Indictments were also issued relating to crimes that occurred in Bosanski Shamats and Birchko, and shortly after these indictments were filed in early to mid-1995, other indictments were confirmed by judges of the Tribunal against Bosnian Croat perpetrators for crimes that occurred in central Bosnia and against JNA members for the crimes that occurred in Vukovar and in Dubrovnik. By 1996, an indictment was filed against Bosniak perpetrators for crimes that occurred in the Celibici camp in Bosnia. And unlike some other tribunals, we had made a conscious decision to investigate and to prosecute where we could gather the evidence all parties to the conflict, not just one party to the conflict. So with the exception of Slovenes and Macedonians, we covered every single, and I don't like this term, but every single ethnicity or party to the conflict. So how did we go about then moving our way up the chain of command? We had a very good crime base, but initially what the Deputy Prosecutor stated to us was that he was going to stand firm and was not going to indict until we had very, very solid evidence. And the solid evidence that we had to put in place, and I'll use the example of the Bosnian Serb investigations that we did. And that was an investigation that I was fairly closely aligned with. And what happened, he said, look, we've got an indictment in Prijedor, we have an indictment in Vlasenica. That could be a defence to one of the senior leaders that it's an out-of-control police official. So what we did then, we went and we did a pattern investigation. And the pattern investigation was what I call, we started in Foča, we moved up to, say, Zvornik, Vlasenica, we went to Birchko, we went to Bosanski Shamats, we went across to Banja Luka, to Prijedor, to Kodavarish, to Sanski Most. And what we found in all of those municipalities that we investigated was that exactly the same thing occurred as what occurred in Prijedor and in Vlasenica. So we started to have decisions that we could say, okay, we're starting to develop a policy here, that this was not just an out-of-control or a rogue police commander or military commander. There is probably a policy here that's in place. So what did we do to then go and link that to the senior leadership? Crime-based evidence was very, very strong. So in 1996, when Dayton, just shortly after the Dayton Accords, we went into what is now known as the Republika Srpska. We took a search warrant with us. Michelle was talking about being innovative. We didn't know whether we could get a search warrant, but we went to a judge and we said, can we get a search warrant? And we were able to get one. We then went into the municipality of Prijedor. We executed the search warrant and we went into the Amaska camp, we went into the Keraterm camp. We did crime scene examinations all throughout the municipality and we seized thousands of pages of documents from the camps and from various other establishments. Then in December 1997, we went and we did search and seizure missions, again by virtue of a search warrant, on the police station in Prijedor, the municipal assembly, the political headquarters, the newspaper and the radio station, etc. And again, we seized thousands of pages of documents. When we started to analyse those documents, we were starting to see that we could start to move up the chain of command. The chain of command then went from the lower level perpetrators to the municipal level in Prijedor. And we were able to issue in 1997, in July 1997, indictments against the leadership of the municipality of Prijedor, Milan Kovacevic, Simo Driljača and Dr. Milomir Starkic. In March of 1998, we then got a little bit bolder and we then went and got more search warrants and we started to do military barracks. And we did the Municipal Assembly in Banja Luka, the East Bosnia Corps, we did the 1st Krajina Corps in Banja Luka, we went across to the borders, and we didn't discriminate against the Bosnian Serbs. We did everybody. We did the presidency in Sarajevo, we did the 2nd Tuzla Corps of the Bosnian Army, We did the HVO in Srebrenica, etc. And we were able to do that because of the internationality of the mandate that we had. In Croatia and in Serbia, we had to seek the cooperation of the different governments of those states. And eventually we got that cooperation to a degree, and we were able to get documents from there. But as a result of all these search and seizure missions and the gathering of the documentation, we were able to work our way up from the municipal level to the regional level. Say in Banja Luka, we had issued indictments against Berginen, Talic and Juplinen, and then eventually to what I call the federal level, with Mrs. Plavsic, with Dr. Karadzic, with Mr. Krajisnik, and then we started with the police command and the military command, and eventually we got enough evidence through the documents, through eyewitness testimony, through the diplomats, through the military officers, etc., to be able to bring indictments against those most responsible. We did exactly the same thing in Kosovo. We did exactly the same thing in Macedonia, and we were able to bring indictments, particularly in Kosovo, we were able to bring the indictments fairly quickly, even before the conflict had finished. The prosecutor often jokes that I arrived at the tribunal before the conflict even started, but that's not true. I just want to now, because time is fairly limited, I just want to move to the issue of the fugitives. Let me first of all give you a few statistics. When I arrived in The Hague, we work in an former insurance building, and they have these magnificent vaults where they used to store all the insurance policies. And we decided that was where we were going to store all our evidence. There's two massive vaults, one on the second floor, one on the third floor. And they were just empty. And you could sort of speak and you could hear, you know, the echo bounding about. Today, in our vaults, we have 9.3 million pages of documents, almost 14,000 audio tapes, almost 9,500 videotapes, just over 4,000 electronic discs, and 14,000 artefacts. And I arrived at the tribunal thinking, I don't think the Yugoslavs would have kept very good records. Trust me, they kept very good records. Because of the 9.3 million pages of documents, 75 to 80% have come from our seized document collections. Let me just quickly touch on the apprehension of the fugitives. It's something that we made a conscious decision of in 1996, that we would form ourselves a tracking team. We decided that we would not be able to rely on states to arrest our fugitives. And we went out and we actively, with our tracking team, and I think in around about 2000, 2001, the tracking team was approximately 20 to 25 people. We developed our own sources, we developed our own informants, and in some instances we were able to supply the information that led to the arrest of some individual perpetrators. But we had to be innovative. Michelle has talked about conditionality and the sealed indictments. The sealed indictments was something that came up when Louise Arbour was the prosecutor. We were told by some officials that if we were to go in and do an arrest using the military, World War III would start. Well, on the 10th of July 1997, if World War III was going to start, it should have started on that day. Because when the British I-4 troops went in to arrest Starkic, Driljača and Kovačević, they had to drag Kovačević out of the Prijedor hospital. He was the director of the hospital. They shot Simo Driljača dead because he shot it out with them, and Starkic escaped. Not a single thing happened. So then we decided, okay, we seal another indictment, and we said to the Americans, we have a sealed indictment. Those British, they're so brave. And we got Krstić. And then we said, you know, the British and the US are so brave, and the French, we got Krajisnik. And then we became victims of our own success, because anybody who thought they were indicted by the tribunal fled to Serbia. And then Carla Del Ponte became the prosecutor. And she had, to her credit, she had the most number of fugitives arrested or surrendered in her term as the prosecutor. And she had what I call, and I've told her this, she quite likes it, I think, it's a bull in a china shop diplomacy. and she would bang the table, she would yell at people, and it worked because we got so many fugitives in at that time. And then when she left, the current prosecutor, Serge Brammertz, arrived. And I think when he arrived, we had about 8 fugitives left. And that was when he factored in the conditionality. We had Gotovina in Croatia, who was outstanding, and we had, I think, 7, like Karadzic, Mladic, Hadzic, Tolomir, Juplinen, etc., outstanding. And he conditioned Croatian and Serbian accession to the EU on full cooperation with the Tribunal. And it worked. And as a result of that, the 161 people that we indicted for crimes have all been dealt with in some way, shape or form. So I'll be quiet now and I'll hand back over to Doug. Thank you.
Thank you, Bob, for cramming about, I guess, 20 years of experience actually into 15 minutes. But it's really remarkable to just get a glimpse, I think, of the scope, the number of issues, investigation-wise, that were unresolved, were sort of an open question in those early days. We're going to stay with that theme with our next panelist, Pete McCloskey. Pete arrived at the Office of the Prosecutor in 1996. It was about a year after 7,000 Muslim men and boys had been executed in a place that at that time not many people had ever heard of, a place called Srebrenica. When he arrived in 1996, Pete had for 10 years prior been a federal prosecutor in the United States prosecuting civil rights cases. And he'd been a prosecutor at the state level in California before that. Pete's career is unique in that it has been devoted solely to developing and prosecuting the Srebrenica cluster of cases. And it's possible that there's no one else who's played a bigger role in a major aspect of the ICTY's legacy, which is the telling of the Srebrenica story and the development of the law of genocide that's so closely associated with that story. Pete, I think, is going to direct his comments today to telling you a little bit about some of the early efforts, some of the early creativity and adaptability, to use Michelle's words, that went into finding ways to get close to witnesses, to develop evidence from witnesses, not the victims, but rather those on the other side, the inside. A key aspect, a vital aspect to all of these cases. Pete, I give the floor to you.
Thank you, Doug. You're going to probably have to turn off my microphone at 15 minutes because, unlike Bob, I'm not sure I can get into this topic, but I will try. And as Doug said, I'm going to talk a bit today about one of the legacies of our team that I'm most proud of, and that is the system we developed to interrogate insider witnesses. And so I'm going to be skipping over what Bob referred to as the crime base. My first 3 and 4 years were spent on the field with shovels, identifying mass grave, mass execution sites, miraculously finding the graves that contain thousands of people, building that crime base. An amazing set of intercepts from the Bosnian Serbs that actually had the people involved talking about those crimes. And then, as Bob said, taking full advantage of Bob's work in Prijedor and other places and jumping on the search warrant bandwagon, which my recollection is slightly different. I thought we first thought about whether we even wanted to do search warrants and whether we would just ask the generals to just take down the barracks. But if I may be wrong on that, and we certainly decided to go to judges with probable cause and ask for search warrants and approach barracks with a legal document in hand. So we followed Bob's example on that and went to Srebrenica areas and got an incredible body of evidence. But in 1999, the leadership of the Srebrenica investigation was extremely frustrated. Myself and Mark Harmon were together in Mark's office voicing our frustrations. And that frustration was based on our experience in the United States. We had, for about 10 years prior to coming to The Hague, been federal prosecutors for the Civil Rights Division, where we traveled around the United States and enacting federal grand juries. And we brought in every member of the KKK that was involved in some function, some crime, and every member of a police department that was involved in abuse or rape or murder. And we put them in a grand jury, which are 20 people from the community, meeting in private, and we asked them questions. We interrogated them. We collected a body of evidence that always formed the foundation of our prosecutions. It was the only way you could investigate those crimes. You couldn't get the FBI inspired to do it. You had to work with the FBI and the local investigators and do it that way. You may have read about, there's a grand jury going on in Washington at the moment. Some guy named Mueller is doing it. And the system of grand jury, when in the beginning I heard that we were developing modern techniques of investigation. Well, grand juries, if you look at the history, they go back about to the 12th century, of course, brought to us by the Brits, as everything else in the system that I practiced. Worked apparently pretty effectively in prosecuting British soldiers that were abusing colonists in the 1700s, and then put in the United States Constitution, enshrined as part of the way we work in the federal government, completely dumped and abandoned in the UK in 1933 for some reason. But in any event, so Harmon and I, with that background, are sitting in his office going, why can't we get at any Bosnian Serbs? We need to get at them, just like we got at the LA Police Department, and when Alan Teeger went after 3/4 of the LA Police Department in the Rodney King case. And it was frustrating. We only went to the RS with Humvees or Russian troops and APCs, and it's hard to get people to talk to you when there's a 50 caliber machine gun behind you or 6 soldiers with weapons. And so we actually did, and I'll never forget this, we pulled out what lawyers do. We went to our body of evidence. Here it is. One little teeny piece of paper, basically, and I'll never forget. Harmon is like this. Pete, take a look at this. Rule 54. At the request of either party, a judge of the tribunal may issue such orders or summonses or subpoenas, blah, blah, blah. He goes, look, should we try to get judges to issue some summonses, some subpoenas? For grand juries, we just went to the local court, we signed up a summons, off it went, no problem. We didn't ever have to deal with any judges. We didn't deal with investigating judges. This was not Europe. We just signed our subpoenas and off they went with the FBI. So we're looking at judges a bit askance. We also see that it's talking about either party, and we didn't want to get involved in the other party. There weren't any other parties at that point. We hadn't even indicted anybody yet. But we didn't want the judges inviting any potential party, and we weren't sure what they were going to ask us. Were they going to demand probable cause? Were they going to get into our investigation, as a French investigating judge might want to do? We were not used to sharing information of an investigation at that point, and we were a bit worried about our judges. We also didn't think we had much chance of anyone honoring a court order. Why would anybody in Republika Srpska honor an ICTY court order? And judges are and should be reluctant to issue orders that will not be followed. They become newspaper tigers and laughed at. So we weren't sure we would get anything from a judge and whether it would even be honored. But then Harmon again, flipping through the page. I could see him just flipping through it. Okay, Pete, look at this, Rule 39. In the conduct of an investigation, the prosecutor may summon and question suspects, victims, and witnesses. Okay, we can do it, just like we did at home. And no judges to worry about. We know Carla will sign it. No process to worry about. Bob haven't hit us with any procedures yet. So we got on, sometimes I tell the story, we got on a typewriter, but no, it wasn't actually a computer we had. And Harmon put summons, bold, underline, and we went to our analysts. We figured, okay, who do we want to summons? And the strategy is simple. Early on, you summons the lower level folks, maybe some middle level folks, people that will have the knowledge and information and may turn and may decide to help you. And so we identified those folks that we knew from our documents, from the search warrants, from the intercepts. And what we're looking to do, which is the same thing this Mueller fellow is looking to do, is bring people in that will make admissions to help us gain evidence of what happened. We're also looking to tie down their statements. They will give us all kinds of lies, and you lock them into a statement. So when they come back as a defense witness, you've got a record for them. You also are looking to create a body of lies that when you know what the lies are, you can point at what the truth is. And when someone that is on the record for lying comes in and testifies, you hit him with that. So that's what we were doing. And so we had a list of names with our military analysts and typed in the first person. And then we said, you hereby summons to appear at, and then was like, where? No, this Bosnian Serb's going to go to Sarajevo. Belgrade won't let us in there, and they're not going to want to go to Belgrade either. So we're thinking, where can we go? So, well, Banja Luka is the capital, and does anybody know what's in Banja Luka? And no. So we finally found somebody, oh, there's a UN base in Banja Luka. There is. And we look it up, and it's this place called the UN International Motel. And it's this awful little place surrounded by razor wire, which is really a motel. But it's the only UN base in the area. So we type in the International Motel on such and such a date, November 1999. We get 20 of these things. Carla signs off on them, no problem. And we get this group, our military analysts, and Chief Investigator Ruiz, Harmon, myself, the analyst, and off we go to the British base that's right outside the motel, which is, again, surrounded by tanks, razor wire, and this is where we have to stay because it's still pretty scary in those days. That morning, we take a huge convoy off to the motel. We get to this motel, we just cringe at this place, and this guy from Sri Lanka with a little blue helmet and a sort of rusty-looking rifle lets us in, and then we sit and we drink Bosnian coffee all day long. Being stood up at 10 o'clock, stood up at 11 o'clock, stood up at 12 o'clock. Nobody's showing up. We're thinking, okay, why are we here? Why did we even think they were going to show up? But by the time we're kind of like this, at 5 o'clock, we get a knock on the door, and the Sri Lankan guy says, hey, there's this guy here looking for the ICTY. And so in our shock, we bring him in, and it's a Bosnian Serb soldier, an excavation operator. And he talks to us about the excavation work he did outside of Srebrenica in 1995, and we get a rather amazing statement. The next morning, 2 guys showed up. So of our 20, we got 3. We did it 2 weeks later, we got 6. We did it 3 weeks after that, we got 8. And so as the months went on, we basically got whoever we wanted, and the other teams started doing the same thing. And the Republika Srpska got very used to this system that we developed, and we had hundreds of witnesses and thousands of pages of material that led directly to people realizing they had hurt themselves in these interrogations, and they pled guilty. and they entered plea agreements with us, and they testified against other people, and all of this has helped lead and been a major factor in all of the convictions in the Srebrenica cases, as well as many other cases that share the same process. So I hope that was my 15 minutes, and that's my 15 minutes of fame as well. But, thank you.
If you don't ask, you never know what will turn out, right? Already, since the panelists have begun speaking today, you've heard references to document collections, intercepts, analysts. In my view, one of the most unique aspects of doing these cases, something that distinguishes these cases from cases on the domestic level, is the nearly preeminent role of analysis. Analysis is always important, of course. But as I mentioned in my opening remarks, when you're looking at the need to understand a constitution and who's got power and military regulations, how military organizations are structured, chains of command, this involves a tremendous amount of analysis. As the thousands and thousands of pages of document collections started rolling in because of the search warrants and the searches and seizures that were being conducted in the field, as Bob's described, there's a tremendous need for analysis. And as these lengthy witness statements and submissions, information's coming in from these guys who are walking into the UN hotel in Banja Luka start to accumulate, you need analysis because someone has to be at the top of all of it. You can't go gather a bunch of stuff and throw it into a system and expect the system to tell you where it leads and how to put it all together in a case that's going to result ultimately in convictions of people who were nowhere near the places where the crimes occurred. Dorothea Hanson arrived in the OTP in June of 1999 as a research officer with what was then called the Leadership Research Team, the LRT. The LRT was one of two groups of analysis, analysts, I should say, that we had during those years. The other was the MAT, the Military Analyst Team. They were looking at the military side, the chains of command and whatnot. Dorothea's side, the LRT, was looking at the political side more and played a key role then in guiding us through the understanding of the complexities of how Yugoslavia existed as a state. It's an interesting side story. Dorothea came from Yale, where she had been in the modern Balkan history program. And some brilliant person tapped into that group from her Yale cohort, and a number of those people arrived and took up positions within the LRT and the OTP and played a major role, made a major contribution to the work that was being done. These were people who generally had some family tie or some other connection to the region. They spoke the language. They could read the documents, which was vital. Probably on her arrival at the tribunal, she got an even deeper understanding of modern Balkan history than she had ever dreamed she would get when she was studying at Yale. So Dolly has come, Dorothea, sorry, we affectionately call her Dolly, has come to tell us about those days in the tribunal and for the analysts, and how that role evolved over the course of the years that she's been here in such an important function. Dorothea.
Thank you, Doug. Yeah, I came on a 6-month contract 18 and a half years ago, and I have achieved the pinnacle of my 15 minutes of fame. I feel is that my statement in one trial is now part of the official proceedings of the ICTY that I was not responsible for the breakup of the former Yugoslavia. But when I arrived, well, I'm called an analyst now. I'm actually called a criminal analyst now. But I arrived as a research officer because that's what I was good at. I enjoyed research and writing, and it turned out that it was something I could use here. And what we did in the leadership research team was analysis, so we can be called analysts now. There were, in the ICTY, also more traditional analysts, criminal analysts, who came from a police background or intelligence background, assigned to the investigation teams. Each investigation team had a criminal analyst. There were also people with a military intelligence background, the military analysts. But we in the LRT were research officers because the kind of analysis we were doing does not fit the traditional intelligence analysis patterns and tools. We had to be fairly creative. We had to apply our previous academic or personal knowledge to this new legal environment. I was hired, as I said, in '99 because the year before they set up these sort of brain trusts, the military analyst team and what was going to be the political analysis team. Unfortunately, because we love TLAs, 3-letter acronyms in the OTP, it would have been Pat to match Matt, but the leader of the team was Patrick Traynor, and it was felt it was a little too cult of personality for his team to be named after him. So we have the more cumbersome name of Leadership Research Team. I remember in the early days telling somebody in the cafeteria, oh, I'm in the Leadership Research Team, and she sniffed and said, leadership, I don't see that we need to research that. Either you have it or you don't, and it turned out she thought we were like some sort of psychologists, but we're not. We were researchers. The strategy team was something that we replaced what was called the strategy team, which in the early days, predating me, was apparently anybody who knew something of the language or the area, was sorting documents and suggesting targets and helping give some direction to the investigations. So out of the strategy came the military analysis team and the LRT. The military analysts all had a background, as I said, in military intelligence, and they were incredibly important in Peter's cases. And there we see more of the traditional intelligence analysis tools like float org charts and analyst notebook network things, because with the military hierarchy, it was easy to work with that kind of chart. So they did a fairly different kind of work than we did. And they did great for Srebrenica. They were able to prosecute so many levels thanks to having all that system. But we were a little different. The criterion for hiring was knowledge of the language, experience in the region, and research skills. And it turned out that, underemployed academics were a very good match for that. And I have been very lucky that my interest in a rather obscure corner of academia led to a chance to really contribute to some much more significant changes. As Doug mentioned, almost everyone I was studying in graduate school with passed through the LRT at some point. partly that's the Balkan way. You do it through friends, friends of friends, but it's also because our skills matched. Another criterion that proved rather difficult to enforce was knowing the language, knowing the region, but not being from the region. I have my nice white bread name. A lot of the people, their names ended in "each," but they had been born in America. One of the analysts, he'd been born in Croatia, came to America at age 2 months, and he had to go through much more elaborate hoops than I did, or others, because he was from the region. But I think this really did allow us to do things that the criminal analysts and the military analysts could not, if only it was the language. That was really crucial to knowing the language. In the early years of the LRT, what we were doing was really figuring out what we needed to know and scrambling to assemble some of the most basic materials we needed, the basic laws, the Constitution, and other laws, which of the countries, of the regions, just to find out the de jure structures. All these countries and even the municipalities in those countries publish something called official gazettes, which list all the laws. It's chloroform in print to go through, but it is necessary to actually assemble who was the minister and what were the powers of the minister or the president or whatever. So we spent a lot of time searching out official gazettes. And it's interesting, the higher the level, the blander, the more anodyne the prose. But at the municipal level, when you could get a municipal gazette, it was nice and specific about taking property from Muslims and things like that. I worked almost all the time on Republika Srpska, the Bosnian Serb perpetrators, so that's the experience I'll be giving. But there were people getting Croatian official gazettes and doing all the Croatian research as well. We also had an open source unit, people who would read the local press and follow the media. They would give a lot of short daily reports, what's in the media, just help people find out who are the targets, what are the crimes being talked about. There were a lot of short bios that we would make, profiles of potential targets, potential witnesses. There were many missions to seize documents, as has been discussed. Also to talk to potential experts, talk to journalists, diplomats, people who knew something about what had been going on. I was just looking over the records to prepare for this. There were many missions to just find someone who could tell us where we should be looking. One of our first writing projects were country studies, where we would set out what are the government structures of each country or each entity. There were case studies to establish the pattern, as Bob discussed, looking at municipalities. What happened in each municipality, and did it follow a pattern? There's a lot of discussion I see in the early years of de jure versus de facto and how to prove de facto powers. The official gazettes would give us the de jure, but how do you prove de facto? So who was good at this? We had some of the early staff were people who had been in the field as investigators for human rights, for Helsinki Watch and Human Rights Watch, journalists, also the materials from the Commission of Experts. So our original research was based on materials given to us from outside, like the Commission of Experts. But thanks to all these document seizures, we were able to enter the middle years where we were figuring out what we could prove with all the stuff we'd gotten. This I really feel was kind of the golden age of the LRT and the intelligentsia. The LRT reached as many as 30 people. We were divided into perpetrator groups, Croatian perpetrators, Bosnian Serb perpetrators, Bosnian Muslim perpetrators. We'd be assigned to work with investigative teams, but we remained together as a group to share our knowledge rather than be sent out just to deal with one team. And this really helped us pool our work as a brain trust. And we began to go through all these document collections that we'd seized. Of the 9.2 million pages, I feel I've seen a fair percentage. There's been a lot of just clicking through documents because, you know, you gotta kiss a lot of frogs before you find the document that'll really help. I calculate, actually, even to have seen as much as 1 million documents, I would have had to average about 1,000 a week, 200 a day. And there were certainly days where I would be clicking through that many. But it's a little daunting to realize I probably never even got close to 500,000, despite all those clicks. Our work product changed. We wrote a lot, continued to write a lot of memos, but they were based on the documents we had collected. They were more focused. They were answering specific questions from investigative teams. They were synthesizing what we'd had. We continued to write municipality case studies, but again, they'd be looking now at, not at witness statements collected by the commission, but rather at our own witness statements and municipal gazettes and police documents, and to show the pattern. And we were looking more at links to the leadership, and we were able to find them. We wrote a who's who database, a nice little click in, who is that name that keeps popping up? So that was a useful research. We had input into the indictments and the pretrial briefs, especially the historical backgrounds and the de jure positions. And one of the things we tried to do was help identify and develop outside expert witnesses who could come for the trials and present the backgrounds or the larger topics. One particular area of expertise the LRT developed was the demography unit. We got one professional demographer and then a rotating number of younger demographers, still broken down by age and sex like all demographers. It's a demography joke. But they produced excellent, again, these excellent materials that we could rely on later for references. They worked with the censuses, but they also produced maps showing the ethnic distribution in municipalities, the settlement patterns, graphs showing the movement in and out of each municipality over the course of the conflict. Really useful, hard information. Our document searches also became more focused, looking at, for example, going to the barracks of armies or the presidential archives. We got presidential minutes and transcripts from Croatia, from the Bosnian Muslims or Bosnian government side, which led to, as I say, these endless review projects. The intercepts, we did a systematic review of all the intercepted conversations, which can be very difficult because you have to really focus on what each one is saying, and a lot of them, the references are very elliptical, but you have to sort of catch the patterns. And the people, I think, who the LRT was employing at this time were, like me, academics. The research and writing skills, I think, were really important at this time, which led to some conflicts or misunderstandings with the world of the police and intelligence, of the investigators who came from a different background to them. We looked, these useless academics, spending a lot of our time doing these large-scale projects, but what we did turned out to be very, very handy when it came to trial, because we would have these large collections. How can we capture the information in a systematic fashion? And it was boring work, but for example, we'd do spreadsheets with everybody who had held different positions or was a member of the various assemblies, so that we could later say, yes, he was a delegate from here. Another was the assembly sessions, for example, going through, reading the transcripts of every assembly session and doing a summary tedious at the time, but then we had a huge collection of what was said at the assembly, in this case, the Bosnian Serb assemblies. The Croatian presidential transcripts, 5 or 6 years worth of everything that was said in the office of the president of Croatia, huge, and entered it into a database. And this is the time where we are developing systems to deal with this mass of information. There used to be something called key file. I don't know if people remember that, for looking at evidence. It was just dreadful. So we then got Xifind to be able to look at the documents electronically, and CaseMap to enter our information. CaseMap there are a series of abandoned and orphaned databases littering the past 20 years. CaseMap was sort of imposed, and despite all its imperfections, nothing is perfect, but having a unified system proved incredibly important. And entering the Croatian presidential transcripts was one of the first uses of CaseMap, itemizing nuggets of information which could then, thanks to this program, be resorted and manipulated. So that was an important development, and it was a learning process. It was far beyond just the LRT, but it was something that really affected our work. Another thing that I don't think we ever really mastered was the dissemination of information. You could find something, you could get a great nugget, find a series of documents, a collection of some kind, or individual documents, but how to share it with the right people wasn't always easy. It relied on too much on word of mouth or knowing who was on your team, but there was no way to stay on top of what was coming in unless you did a new search every week. You couldn't know everything that was coming in, and I think that's something that, a practice that could have been, that certainly needed improvement. So those were the middle years. A lot of hard work, synthesizing a lot of material, but it really paid off in the latter years, which Bob was talking about, the pyramid approach of crime base to the leadership. It was a similar process of starting at the bottom with so much information and selecting, so that the last few years have been much more closely focused. The work of the analysts has gotten more narrow as well. Not so much working on investigations or not part of a lot of interviews, closely linked to the trial teams. And our universe has shrunk down from all the pages to evidence, which is something very different from documents. And as our universe shrinks, it's easier to master, but we kind of miss those great documents that never got in. But during the trial phases, thanks to these databases we had built up, or the summaries or anything, we were able to get information quite quickly. And thanks to limited universe, we knew them. So the trial phase is, it's only the culmination of all this work, but it is the most rewarding in many ways, especially for me. The best part is the defense phase, when the prosecutors will say, okay, give me your 5 best documents for this witness. And, what I suggest gets said in court when the judges are asking questions, if I have the chance to actually follow a court, and I can send an email and the prosecutor stands up and answers with what I sent. It's a very rewarding feeling. I liken us to powder monkeys just getting ammunition to the prosecutors. Just keep sending ammunition, and they're getting more and more focused. Their aim is improving, and can be very precise. Not improving, sorry, it was always very good, but very precise, very precise. But a problem arose that we have all this information, and over thousands of pages, we've synthesized a body of knowledge on some topic that the prosecution wants to present to the court. They want an expert witness. Traditionally, they have used outside expert witnesses for this kind of presentation, but only someone who had worked in the Office of the Prosecution for years could know enough to present it. We tried to give it to outside experts, but in doing so, we would be making a selection of documents, thereby prejudicing already, potentially prejudicing their impartiality. So it turned out that the only people, or else if they'd have to work a year or so in our archives anyway, so they would be employees of the prosecution. So it turned out that the best people to present the synthesis and analysis of these large collections were already in the house, and a lot of them came from the LRT or the military analysts and the demographers. So I became one of the expert witnesses. The man who led my very first expert testimony is right there. 14 binders, I recall, stretching around the courtroom for all my documents. But another example, Pat Traynor, my boss, he became the expert witness on the Bosnians for Karadzic and the Bosnian Serb leadership. First, we had contacted an academic who sent us a nice 12-page essay on Karadzic, and we realized this is not going to work. Traynor's report, which he wrote with the contributions of all of us, ran to nearly 200 pages, with 900 footnotes, citing 1,600 separate documents. Again, there's no way an outsider could know all those things. But the courts, many chambers didn't like an in-house expert. We had to develop policies for how to treat an expert, keeping a certain distance from the trial team. It was a scandal, apparently, when a birthday card for me was circulated among one of the teams I was an expert witness on, even though I could be consulted on certain things, but not on my area of expertise. But it was in one of those trials, Stanisic-Županin, when the defense was insinuating that if I knew the language and studied the area and had been living there when the conflict broke out, surely I was a spy. So I got to say, no, I'm not responsible for what happened. So the last few years, since the biggest trials have ended, it's been a lot of regurgitating the same information. It's been so thoroughly processed. Our ammunition is very well targeted, that there's not the excitement of the earlier days of just, okay, I'm an academic, I like going through archives. It was really fun. We're not meeting, and if we do come across anything new now, well, it's too late, which is anything that hasn't entered the world, the universe of evidence, it's just no longer relevant. But the reason it's easy now is all the hard work that all my colleagues did during those golden years. What we've learned from this, I think, as Douglas said, that analysis can be very central to these kind of cases, but the traditional analysis tools don't work if you're not dealing with a nice finite organization. Plan ahead for millions more documents than you can imagine ever having. Plan how to enter them, record them, analyze them, use them systematically. Quality control is really important. One of the most important documents, the analysis of combat readiness is one of its entries is simply a document in Cyrillic. So that doesn't help you much. You need a system consistently applied with quality control for entering the information, like case map. You have to have a policy, it turns out, for dealing with people who know too much, the in-house expert witnesses. And the importance of language. I think that we were really able to accomplish so much thanks to the language. And try to prevent reinventing the wheel, because it seemed to happen every time. We'd be repeating things, talk to each other, find a good way of talking to each other. That's it.
Thank you. Thank you. So we've done our investigation. Pete's been out investigating suspects at the UN hotel and getting statements. The documents are rolling in. Dorothea and the LRT, the MAT, cranking out their analysis. with these deluxe systems they developed. We're in court. We've got the witnesses, Pete's witnesses. We've got the evidence, the documents. But we still haven't been told what it is we have to prove. Because ultimately, that's not for us to decide. It's for the judges. And that's going to have to be litigated in the final trial submissions and in the trial judgment. And then from there, I can guarantee you there's going to be an appeal. Laurel Baig joined the tribunal in 2005, although she had experience with international criminal tribunals before then, as you'll hear. She came from Canada, where she was a human rights lawyer. She's worked not only at ICTY, but ICTR, and in chambers at the ICTR and at the STL. Sorry, Special Court for Sierra Leone. Laurel has been in the middle of many of the discussions I alluded to during my initial remarks about development of law. What's the position to be taken? How widespread and systematic is enough? All the rest of that. These were questions that were never going to be clear until they made their way through investigation, trial, and appeal. Laurel, please tell us about that experience on the appeals side.
Thanks, Doug. So I first walked through the doors of the ICTY in September of 1998. And I came, as Michelle Jarvis did, and looking around the room, as a number of other people here did, as an intern. And that experience was so important. It really convinced me of the power of the law, even in times of chaos in an armed conflict, really convinced me of the promise that was offered by the international criminal tribunals to help to restore peace and security. And to give you a little sense of why I was so impressed by that experience, I looked back at what was happening in the autumn of 1998. And inside the courtrooms, we had the Kupreskich and the Alexovsky cases. They were happening while I was there. The Celebici and Forinzia trial judgments were delivered. Goran Jelisic, a notorious and cold-blooded killer, came to the court and pled guilty. The Krstić indictment charging genocide in Srebrenica was confirmed in November, and he was arrested in December. And the Tadić appeal, the first appeal from a contested trial, was ongoing. And behind the scenes, in the OTP, Peter McCloskey was typing up some summonses, and Bob was out gathering documents, and witnesses were being interviewed, mass graves were being exhumed. Slobodan Milosevic was still the president of the Federal Republic of Yugoslavia, and he wouldn't be indicted until early the next year. And Kosovo was still a war zone. The then prosecutor, Louise Arbour, was pursuing every possible opportunity to get herself and her investigators into the crime scene. And as a young lawyer, this was inspirational and life-changing work. And there really was a sense in the office that everything was starting from scratch. So one of my most challenging assignments was to research the elements of the crimes of extensive and wanton destruction under Articles 2 and 3 of the ICTY statute. And I remember sitting in a room with my boss, the head of the legal advisory section, Bill Fenrick, and some other people with stacks of books piled up and printouts. And our task was to try to divine the concrete legal meaning of the terms wanton and extensive and destruction in customary international law. So there weren't any textbooks at that time that gave us the answer, or practitioner's guides, or Google research that we could do. And we had to draw on every imaginable resource. So we had the Nuremberg Charter and the Hague regulations and military manuals from around the world. We had human rights sources. We had dictionaries in multiple languages. But we only had very limited jurisprudence to work from. And mostly these were cases dating back to the Second World War. And I can compare that to today, where as a result of the hard work and dedication of everybody who's been involved in this project, there's now a considerable body of modern case law to draw on. And many of the cases that the OTP has championed on appeal over the past 20+ years have led to major advances in international criminal justice. And so much so that when I was asked to pick out some of the highlights, that was a really challenging task. Our cases have really laid the groundwork for all of the courts and tribunals that have followed. So to give you some quick highlights, let me start with Tadic, because it really is the beginning of the story. And I'll touch on 4 themes that emerge from the Tadic case that we can sort of quickly follow through to the present day developments. The first theme is the gradual articulation of the crime of persecution as a crime against humanity, and how this emerged as the quintessential crime of the Balkan conflict. Persecution legally describes many of the factual scenarios that we commonly refer to as ethnic cleansing. And these are patterns of crimes that we saw repeated across the former Yugoslavia. And yet, at the beginning of our work, the importance of persecution wasn't fully understood. In Tadic, for example, the trial chamber thought that all crimes against humanity required a discriminatory intent. And the prosecution successfully appealed, arguing that discriminatory intent on political, racial, and religious grounds is unique to persecution. And through some bold charging strategies and lots of legal legwork over many appeals, starting with Tadic, moving through cases like Kwočka, Blaskic, Brjanin, the details of this crime emerged. And through these cases, we've uncovered the power of persecution as a charge to bring together a broad range of criminal activity under a single umbrella crime and to connect that with a discriminatory purpose. And that's been a very powerful tool for the prosecution. The second theme emerging from Tadic, which will come as no surprise to many in the room, is joint criminal enterprise as a mode of criminal liability. So JCE, joint criminal enterprise, is a mode of criminal responsibility, and that's really just a theoretical explanation as to how everyone working together in a group to pursue a common criminal purpose can be held criminally responsible for the results. So Tadic was acquitted at trial of the killing of 5 men that occurred during an attack by Tadic and some others on a Bosnian village. And the prosecution argued on appeal that regardless of which of the people with Tadic actually killed these 5 men, that Tadic should also be considered criminally responsible through the common purpose doctrine. And as a result of the prosecution's appeal, the appeals chamber examined customary international law and determined that in such circumstances where people come together to pursue a common criminal purpose, each of them contributing in their own way, then all of them are jointly criminally responsible. And the prosecution took this a step further in the Brjanin case, where we successfully argued on appeal that there can be situations where the principal perpetrator, that is the person who's committed the crime with their own hands, that the principal perpetrator doesn't even necessarily need to be part of the criminal plan. And this kind of joint criminal enterprise, where those who are sharing the common plan are using the forces under their control as tools to commit the crimes, this type of joint criminal enterprise has been critically important to our ability as prosecutors to hold the senior leadership, the big fish, accountable. So using joint criminal enterprise and other modes of liability that were built up through our trials and appeals, we've been able to reach the decision makers at the highest level and not just those who are implementing the decisions. Another theme emerging from Tadich and following through to the present day is the OTP's commitment to prosecuting sexual violence crimes. In the Tadich appeal, the prosecution successfully overturned 2 acquittals for sexual violence. And this is an area where the work of the appeals section has been particularly important, both in protecting the hard-won successes at trial and in advocating for the correction of errors where the prosecution has been less successful at first instance. One of our most important cases was the Cyanovich appeal. And at trial in that case, the prosecution proved that there was an ethnic cleansing campaign during which Kosovo Albanians were targeted for mass deportation and other forms of extreme violence, including threats, beatings, killings, and other intimidation. But the trial chamber treated sexual violence differently, finding that it wasn't foreseeable in that kind of campaign. And the prosecution appealed, emphasizing the importance of ensuring that different evidentiary and legal standards were not applied to sexual violence crimes. And ultimately, we convinced the appeals chamber that sexual violence, just like other forms of violence, was a foreseeable consequence of this kind of expulsion campaign. That there's no difference in law or in fact, there's no reason in law or in fact to treat sexual violence differently than other forms of violence. And this has been a real milestone precedent of considerable value, both to efforts at preventing sexual violence during armed conflict and to prosecution. And this brings me to the final Tadich theme, which appears in both the very celebrated interlocutory appeal on jurisdiction and the substantive appeal against the Tadich trial judgment. And that theme is the translation of the laws of war into international criminal law norms. So the ICTY statute gives us the power to prosecute violations of the laws and customs of war, such as those enshrined in the Geneva Conventions and other international humanitarian law treaties. But it only includes a non-exhaustive list. It doesn't definitively set out which breaches of the many rules of international humanitarian law amount to war crimes. So to determine whether conduct was criminal under the laws and customs of war, the Tadich Appeals Chamber emphasized that there had to be a careful check to ensure that the fundamental principle of legality was being observed. In short, the Appeals Chamber was requiring not just a breach of a rule, but a crime. And in later cases, the chambers regularly applied what became known as the 4 Tadich conditions to conduct, to conduct this legality check. So for example, in the Galich case, another OTP milestone on appeals, the appeals chamber applied the 4 Tadich conditions to affirm the war crime of spreading terror among the civilian population. And this takes us full circle, back to the war crimes of wanton and extensive destruction. This careful checking that's required to make sure that the elements of the crimes were already in place in customary international law before the conduct occurred. This was precisely what I was being asked to look at and to check as an intern back in 1998. And 2 decades later, I'm pleased to report that the elements of wanton and extensive destruction are now well established. We now have many modern cases that explain and expand on the meanings of these terms. But as with all laws, there remain open questions as to how they will apply to particular factual situations. So when you think about destruction in a tiny village consisting of only a handful of houses, how many of those need to be destroyed for it to be extensive or wanton? Or the destruction of dual-use objects that are used by both the military and civilians. How do the laws apply in that situation? So some of these issues have been raised in the ICTY's last appeal, the Perlich case, and we expect judgment in that case at the end of the month. So before I conclude, I really want to take this opportunity to express some gratitude. When I started doing research for this presentation, I was really struck with how many people from all over the world, how many exceptional colleagues contributed to the work of the OTP over so many years. And in the OTP more generally, in the appeals section, and across the tribunal. And I wanted to give thanks to them and to all of the witnesses who came before our court and made this all possible. Because it's very obvious when you look at the record that together we've achieved something truly historic.
Okay. Laurel, thank you for giving that insider's look into some of the themes and the development of the law in all these areas. The wanton destruction is interesting to me because I was one of those people back in '97 who was fretting over the same thing. What is wanton destruction? You have to destroy every house in the village, or half of them enough? I mean, people lost sleep over this kind of stuff. Because if you didn't get it right, you might lose the charge, even though you'd proven the crimes occurred, right? You may still not get the conviction, the responsibility may still not be assigned. Let's go straight to the questions now. We've got time. Actually, I had been told earlier we can go till 7:10. Actually, now we can go to 7:15 if we want. We are happy to answer any and all questions from you. Anybody going to kick it off? Yes, here. Oh.
Thank you so much. In the first, sorry? Oh, my name is Puck Leroy. I'm from Pucks for Peace. I was wondering, in the beginning of Michelle's presentation, she said that there is now, at some point there was a new strategy in which the court focused on capacity building in the region. And I was wondering, how do you see the future of these trials in the region as it is today?
Do you want to take a round? Or? Yeah. Do you want to take a round of questions, or do you want me to respond?
Michelle, please. Yeah, we can just, I think, one at a time.
Thank you for the question. I think it is such an interesting aspect of the experience that we've had at ICTY, as I said, because it wasn't on our radar at the beginning, but it has ended up being such a crucial component of our experience. And I think we often say in the office now that the future of international justice is national justice. I think one of the big lessons from the experience of the two ad hoc tribunals, which have been purely international tribunals, has of course been that if at all possible, national justice has many, many benefits. We've seen models like Special Court for Sierra Leone, which of course was located much closer to the affected community, and that certainly had advantages if it's possible to do it that way. In terms of the region that we work with, the former Yugoslavia, of course, we have seen a very significant evolution over the years. We've seen regime change, we've seen the conditionality policy and integration into the EU, which has changed the climate and the approach in some ways. In Bosnia-Herzegovina, of course, it's probably the national jurisdiction globally now that is prosecuted the most war crimes cases. I mean, we often talk about an issue like conflict-related sexual violence. At ICTY, I think we've had about 93 indictments over the years, but Bosnia now is well into the hundreds in terms of the cases that it's prosecuted. So it's an incredibly rich and evolving body of jurisprudence that is being developed at the national level. The challenges are, of course, still intense, I think, for national accountability. All of the challenges and difficulties that we've been talking about, of course, play out at the national level in similar ways or even in new ways. These cases are very different from what national prosecutors are used to, what national judiciaries are used to, and the expertise that we've slowly developed over these decades, of course, now has to find its way into these national systems. So for us, strategies for figuring out how do you do that, how do you try and take the incredible knowledge of people like Dorothea or Laurel or Pete or Bob or Doug, I mean, how do you make that available so that we don't have to start from the beginning every single time? So we, of course, over the years have been working very closely with authorities in the region, trying to help convey the experience that we have. We've transferred some of our cases directly, as you know, as part of the completion strategy. So some of the cases being prosecuted against lower level perpetrators or where there is an argument that the crimes themselves are less grave than the crimes prosecuted at ICTY. We've been able to transfer those back, and as part of that there's been a whole overlay of assistance and peer-to-peer discussion going along with that. I mentioned two other strategies which I'll just expand upon a little bit. We developed over the last years our liaison prosecutors program, and also we've had interns from the region working in our office. That's been another incredibly important way, not only to inject their expertise into our work, but also for them to be able to have access to the 9 million pages in our evidence collection, the expertise of the people in our office in a very meaningful day-to-day way. And on the issue of conflict-related sexual violence, Carsten mentioned at the beginning that we have done an extensive legacy project on this, resulting in a publication last year. And in order to provide a vehicle really for disseminating those messages to prosecutors in the former Yugoslavia, but also more globally, we set up a network through the International Association of Prosecutors focusing on this topic. And the idea very much is now to try and connect prosecutors globally in different jurisdictions so that we can really have a much more sophisticated discussion about the operational challenges and strategies and solutions on these topics.
Just to maybe follow on from that just a little bit, I think that maybe one of the lessons learned, based on my own experience, I actually lived and worked in Kosovo as a prosecutor at one time in my life, Sarajevo as well. It's not just about building capacity with locals in their local domestic systems. There was a time when the international community was of a mind that they were going to go to these places and show them how it's done. This is how we do it. This is how you should do it. And that was rightly met with resistance. And in some ways, it wasn't always such a well-informed practice from the side of the internationals to sort of be coming in and holding forth, telling those professionals in the domestic systems how to do their job. And so when you talk about capacity building, it's also, I think, about building a process in which domestic authorities can build into their own systems the best of what's happened on the international side, but also recognizing that there are aspects of their legal systems that are their own and that are going to have to, and that the international bodies of law and the international professionals are going to have to bend as well in their direction. It's not just a one-way street. Next question. In the back. Yes, Xifang.
Hey, thank you for the wonderful presentation. My name is Xiaofan. I'm currently an intern for OTP, for ICTY OTP. My question is related to the OTP investigation and the domestic legal system. So I wonder, is there any situation where, like, the rule ICTY followed during the investigation is of like lower threshold or provide less protection to the suspect than the domestic law? And if there is like any situation like this, is there any way for the suspect or the defense to like appeal or just to request a review of this like in front of the court?
I can think of one, probably quite possibly the most well-developed legally issue that relates to that, which is the way in which accused at the ICTY could be sentenced once they are convicted, the maximum sentence to which they could be exposed under the ICTY. Now, this is not so much in the, well, it is actually in the legal, in the domestic systems as well. There was always, one of the early conflicts in the law, in our cases, was whether a life sentence could be imposed under ICTY practice when, in fact, the law of the former Yugoslavia was more limited to the extent of the penalty that could be imposed. And that was litigated in the ICTY, and jurisprudence was developed that, in fact, the sentences can run longer than 20 years, which was, I believe, the maximum that was generally in place in the former Yugoslavia. Now, when you move those cases back to Bosnia and Herzegovina, I remember one case, and David Schwendeman is here. He may know about this in more detail than I would. The Maktuf case, that ICTY rule was applied. It came back to the Bosnian system as part of the package of laws and things that were going to be used in a domestic prosecution. And this person was prosecuted under the subsequent law that came in later, which increased the sentences, and that was because that was the basis on which the ICTY jurisprudence approved that. Ultimately, that was struck down in the domestic system, and that's probably, for me, the best known example of how an accused sort of benefited from a more lenient application applying in the domestic system than was the case at ICTY. Yes, here.
Thank you for your lecture. My name is Venimira Petrova and I'm from the Hague University. So my question relates to how did you approach witnesses who are reluctant to testify, such as victims of sexual violence, or witnesses that would simply lie on the stand? And could you say there is a big legacy of the ICTY in this regard to the approach of these kind of witnesses? Thank you.
Do you want to talk about probably the latter of the two, which is the approach to witnesses who don't want to testify and who are perhaps not being fully truthful when they do testify.
Yeah, I've spoken to many people that were reluctant to testify. The first category would be among the victims. One of our most important early witnesses, it was an eyewitness of what was going on in Potocari. It was a woman, and she had seen one of our named accused do some commanding and some not so nice things, and we desperately wanted her to testify, and she just didn't want to. And she had herself survived the ordeal as a young woman, and we didn't understand what the problem was until we looked a little bit more into the background and had found that she had been held at one of the checkpoints on the way out. And we'd learned what happened at that checkpoint to some women, and we had finally figured out that this woman had obviously been abused significantly, and she did not want to have to go face cross-examination and the world on the world stage. And she was actually very close by, so she was easy to get, and we could have subpoenaed her. And had this been in Santa Clara County, and she had been a rape victim and was able to identify her rapist, I probably would have subpoenaed her and forced her to come. Where in Santa Clara County, it's more important to get a rapist off the street sometimes than that a person's unwillingness to do it. But in this case, it was a much larger case than one rapist, and there was lots more evidence, and we just decided we were not going to do this to this woman. And we, despite the fact that she had some amazing evidence, we did not force her when we could have, and it did encourage me to talk plea agreement with the particular fellow that she had seen, and we actually ended up getting a plea agreement. So we didn't force her to do that, though we could have, and in another life I might have. Though I think some of my Bosnian friends would not have spoken to me after doing that. The more adverse witnesses that don't want to testify because they don't want to have to implicate themselves or others, we were able to get orders and actually bring them in if necessary, and we did do that where necessary, and we were getting cooperation from the countries to do that. We didn't have to do it often. I was always amazed at how respectful the folks from the former Yugoslavia were when they got an order from someplace. They would actually follow up and have to come to the Hague.
Yes, up in the back.
Thanks very much. My name is Joe Powderley. I'm an assistant professor here at Leiden University. Let me express my thanks to the panel for a really fascinating discussion this evening. And I can just imagine in generations to come that people will want to learn about this institution that was the ICTY. And when I first got into international criminal law, I was fascinated by the memoirs that existed from those who were involved in Nuremberg, the Francis Biddles, the Ben Forenzas, the Telford Taylors, who in rather dramatic but yet fascinating way expressed their memories of the Nuremberg trials. So I'm not going to ask you a hardball legal question. I'm going to ask you a softball journalistic question, which will probably be a little bit challenging for you to answer because you've so much accumulated experience. But for each of you, what was the most dramatic moment in your time at the ICTY? Be it for Bob, and I've been lucky enough to have some conversations with Bob about questioning a particular witness who gave a piece of information which you really weren't expecting to give, or to Peter, examining a witness on the stand who went in a direction you weren't particularly expecting, or even for Dorothea for a document which just out of nowhere came up, and it was this golden piece of evidence which opened the door into all kinds of other avenues. So that's what I'm interested in, and I'd love to hear your thoughts on that.
Okay, we've got about 5 minutes or so. Maybe in a minute or so, each of us could take that on as the last roundup for what is ultimately about our personal experience.
As for documents, I think the most chilling one that when I read it still, it strikes me as known as the Nazi document from one municipality in Bosnia, Serb-held municipality, where Muslims were forbidden to gather in groups of more than 2 people, to swim in the rivers or to fish, to move outside their area of settlement. It's just the restrictions are reminiscent of the Second World War. From my personal experience, the most dramatic moment for me was just before beginning to testify against Radovan Karadzic. I'd heard his voice in speeches and on intercepts, and I was there in the room. I heard that voice. I still didn't have the nerves to turn and see him, but I heard the voice that I'd heard for years. And then as in the course of the proceedings, realizing here we were in a small room with basically ordinary people calling him to account, saying what you did is a crime against humanity and we will not stand for it. And it wasn't presidents trying him, it was my colleagues, and it was ordinary people on the other side as well. And the power of that situation, I'm still getting goosebumps as I talk about it.
The most dramatic thing that I recall happened in closed session, so I can't tell you.
Yeah, I mean, it's a great question, Joe. I mean, and I think the problem is that we're still so much in the midst of finishing off our work, we haven't really had a proper chance to reflect. I mean, there are so many things that come to mind, but maybe the thing that I'll mention is, of course, I've spent many years as a lawyer, so a lot of the legal developments are really dear to my heart, and the issues that I worked on I will really remember. But more recently, the last 6 or 7 years, as I've been working in the immediate office of the prosecutor, and in the last few years as the prosecutor's deputy, I've had increasing opportunities to interact with the victims' associations from the former Yugoslavia. So, of course, there are quite well-developed associations on all sides of the victim populations. And one group that Pete knows very well, of course, is the mothers of Srebrenica. I mean, these are the women who survived Srebrenica, the massacre, but many of whom lost virtually every single male relative in that tragedy. And so the opportunity to meet with these victims' associations, to hear directly from them what they think about our work, very often they're coming at really momentous times in the tribunal's work. So when Mladic was finally arrested, when Hadžić was arrested as the last accused, when the significant judgments are rendered, and we regularly meet with them in the office of the prosecutor, as do other parts of the court. And they are really amazing memories and discussions I think I will never forget. And I do think, there's a lot of discussion now about, is the criminal justice project worth it? Are we spending too much money on this? Should we be spending more money on other things? And of course, reparations and broader issues are really important. But for me, based on those discussions, I could never, ever agree that for the victims, criminal justice is not important. It absolutely is, and it's been incredible to see their reactions, a little bit as Dolly was saying, for them to see Mladic, Karadzic and the others held to account in the courtroom. Yeah, I mean, that is a really incredible thing to witness.
Bob?
Yeah, I mean, there's many dramatic moments, but I think the most satisfying moment I had, when I arrived at the tribunal, we were continually told, probably for the first 2 years, not to get comfortable, don't buy a house. because you're not going to be here for very long. 2 years, that'll be it, and you'll be all sent home, and you'll never get an indictee, you'll never have a trial. So I think the most satisfying moment that I had was when the prosecutor and I were told that Goran Hadzic had been arrested in July 2011. He was our last fugitive, and we proved them wrong.
Wow, hard question. Hard question because there's so many competing moments, and because dramatic contains both the positive and the potentially negative. And because my work is so legal, we've had so many of those highs and also a number of lows. But I think for me, one of the standout moments is something that happened outside of court. And again, it's about contact with the victims, but not just with the people that I thought were victims. So a couple of years ago, I had an incredible opportunity to attend the Women's Court in Sarajevo, which was an NGO civil society court, not a technically legal court, where in a closed room, women stood up and talked about their experiences in the conflict. And there were women from all sides of the conflict in the former Yugoslavia. And after hearing a number of women who were on what I traditionally considered the victim side, a woman got up and told about how she had lost all the men in her family after they had been forcibly conscripted into military and paramilitary groups. And it was a big light bulb moment for me. I'd worked on this conflict and other conflicts for many years, and I'd never really appreciated until that moment how serious the loss is on all sides and how tragic war is from every angle. And that was a really dramatic moment that changed how I think about the work that we do and the impact that it has on people's lives.
In my opening remarks, I referred to when the Blaskich trial, when we were trying to prove death. You have to actually, you charge murder, you have to prove that somebody died, and you have to prove who that person was. And we didn't have death certificates. There wasn't any documentation. And so we would ask our witnesses who were victims themselves, family members of those who had died, to bring photographs that we would offer into evidence through their testimony. And during the Blaskich trial, one man came, he was an elderly man, I still remember his name, and he had a photograph of his wife who had been killed in the village on the day of the attack, when they and the other people living there were running away. She'd been shot down and died next to him in an APC when the peacekeepers were trying to get her to a hospital. His house had been burned during the attack, and this man was living alone in a different place because all the Muslims from where he was from had been expelled. And he didn't have any photos of his wife, but his daughter had one, and he brought that photo. And what we would do would obviously take the photo and make a photocopy, make all the copies for all the judges and the registrar, and color photocopy. And our practice was to make an extra few copies for the witness himself or herself to take back. And when we gave him that color photo that he could keep for himself, I think that it had a tremendous impact on him. And yeah, it was a time when I was new to it all and sort of had thinner skin than now. And it's just sort of a recollection that's always had a strong impact on me. So that's my moment. Thank you very much for coming and hearing our stories. And good luck to all of you. I know so many of you are interested in carrying this on. And good luck to you in in doing just that.